Valhalla made us late, by the way. I don't know why.
Pretty good.
I like it. I like
It's
it.
it's a really jammy intro. I enjoy it a lot.
It's good. It's going to be sad tomorrow when I have to trim it out of my monetized stream.
Are my streams like not up and running because I have like nobody here? We went from like 12 to like 6 people. I'm wondering if my streams are like up and running now. Hang on. Something went wrong. Try again. Oh, that's fun.
What'd you do?
I have no idea. Something went wrong. Try again. Yeah, it's really weird.
With just your streams?
I don't know. I've got a lot of people in chat, and I mean actively talking, and it just says that there are 2 people watching, so it might be a YouTube thing.
YouTube has been acting awful silly here lately.
Oh, here we go. Okay. Nope. Now, okay, now we're up and running. Oh my god. Okay. Woo. We're good.
YouTube's having issues. I think we're good. I think we're just going to roll with it.
Okay, so today we watched day 13 of Wisconsin versus Zachariah Anderson, and with that came the defense's really the majority of their case. So we started out today, David. Who was our first witness?
Well, our first witness is Corleone again. From The Godfather. He did finish the cross-examination, or he took the stand first to finish the cross-examination. Not really a whole lot to say about him. That really wasn't gathered yesterday and spoke about yesterday. But that was the end of the state's case in chief, by the way. So, and like I said yesterday, we move into the defense's case in chief. Now, they start off with a good one. Out of all of them, they start off with a good one. And this is Avila. Is that how you say her last name?
Julianne Avila or Avila.
Avila, whatever. Anyways, she is the state's crime lab technician, right? So she's the state's own expert being called for the defense. That's usually a really good thing. And they did do a really good job with her on direct. However, on cross-examination, I feel like they like all the hard work sort of got knocked back down a bit, particularly with the one question of, based on your experience, when you looked at that stain, did it appear to be blood? And she said, well, it appeared to be blood, and it looked different than the other stains, right? Which, again, I don't know how that's allowed, but I feel like that's enough to have like completely discredited the rest of her testimony, although she had some really good things to say, such as there's no indication of blood inside that vehicle because they didn't test for
testing, it. Yeah. Now there were a couple issues with her testimony that I don't think that the defense did a good job following up with. She mentions that there were bleach wipes in the van. Now, independently, we've looked at Clorox wipes. Clorox brand wipes do not contain bleach. And the defense really failed to assert that. So there's Clorox wipes, but there's no bleach in those wipes. So we have a failure to really express that to the jury itself, because the shopping that we've already covered and buying these wipes was supposedly something that was meant for some sort of crime cleanup, but then we don't have complete information. So this is just another example of the defense dropping the ball on the case today.
Yeah, definitely. That yeah, I know something's going on with the views for Valhalla.
I don't know.
But yeah, so that was a huge problem that the defense dropped the ball. And again, I really was, when I was watching this trial the first go around, I was thinking the defense doesn't have to do much of anything, because in my mind, there's not enough to connect the dots here. But as I'm rewatching it, knowing that he's found guilty, I'm looking at potentially some of the shortfalls. And unfortunately, there's a lot when it comes to the defense. So I don't know.
It did feel like Nicole kind of ran away from this witness instead of questioning her and getting to some of the meat and potatoes, rather.
She got a couple of points out. You know, there was a really good, strong line of questioning where she was talking about the cleanliness of the van and the state of the van, and got her to say repeatedly that the van was full of clutter and that it was not clean. She actually said about a whole area of the van that were presenting pictures for. She said, "What was it cleaned?" Was Julianne's testimony in response. Cleaned? No. Like it was like an absolute, it was definitive. No, it was not clean. But that it just felt like that whole exchange was lost on the jury. It is not a clean van. It was not cleaned. It was cluttered, full of filth, and disorganized. And people just didn't seem to pick up on that.
Yeah, it should have been emphasized a little better somehow or another. Agreed.
Yeah. That's the main issue. I feel like everything is just sort of kind of limping across.
Right.
And they're not
you're getting the right questions answered, but you're not emphasizing what that really means in the bigger picture, right?
Yeah.
Exactly.
Like, yeah, it was dirty, but that then means that you have everything. Nothing got cleaned in the van, right? If it was dirty, then he very obviously didn't use Clorox wipes to clean the van and it's spotless. It just needed to be made. It needed to be pushed one step further.
Yeah. And you said that there's, what appears to be a bleach stain, but then there's wipes that don't contain bleach, even though you just said they're bleach wipes. There's just so many holes in how they could have really cemented the argument to the jury, I think. David, I was just looking back at my notes. There was one thing about the rest of the state's case that I wanted to point out, and that Gravely spends a lot of time talking about the void of cell phone activity this morning. So in the first witness during Korea's testimony, they go back and forth, and he's asking a lot of questions, trying to drive it home that there's a gap in Zach's cell phone activity, and it's during these hours on Sunday the 17th. And the defense's response is, well, there's other gaps in cell phone activity, but it's during other random times. It's not, during like the 7 p.m. to 11 p.m. time shift or time window. And I just wanted to point out that like this sort of insanity that we're now using the lack of evidence as proof,
as evidence, right,
is just something that bothered me so much. As I mean, they wasted almost an hour trying to just get this information in, just to try and establish that it must be the time because the cell phone wasn't moving. But that doesn't actually mean that a crime was being committed at all. Not at all. Not even a little bit. There's a lot of other reasons why a cell phone wouldn't move. So
certainly not proof.
Right. That's the thing. It's like the absence of proof is proof. And that's what I was trying to say yesterday when we talked about a lot of the statements that Zachariah made to the police. Even if they're innocuous statements, they're using them against him. And that's why you don't ever talk to the police. So hello, Susan. But yeah, so there were a lot of issues with that as well. I wanted to catch up to who I feel are the two biggest failures, defense witnesses today by the defense, and it's these two individuals. This is Jennifer and Nathan, and why I think they're a failure. So it's clear that the defense was calling them because they made statements to the police at the time that they didn't hear anything on this particular date at this particular time. The problem is that both of them testify that we were probably sleeping. That is a clear indication. Also, I want to say about, was it Nathan? Nathan's testimony, he said, the question is you made a written report, or did you make a written report to police? And he says, I don't know. And she said, well, if I showed you something, would it refresh your memory? Showing the written statement, obviously refreshing his memory. Why wasn't that discussed with this witness before you put him on the stand, so he knows there's a written report because you gave it to him to look at before he got on the stand?
Absolutely. That means that the defense had never actually talked to them about their report.
Nope.
And
this was a wasted opportunity.
Tremendous. Yep. Yeah. And I mean, the state went through the diligence of bringing everyone in to meet with Gravely one-on-one. And somehow get multiple witnesses to change their testimony. But the defense couldn't be bothered to meet with the witnesses before this homicide trial.
And that was the same thing with Zach's friend, your friend. What's his name? Anthony?
Andrew.
Andrew. He came on the stream with us a couple of days ago, and I asked him specifically, "Did you met with Gravely before your testimony? Did you talk to the defense?" And he said, "Nope, didn't talk to him."
Yeah.
So,
I mean, to be fair, the defense probably should have asked me to come up and be a witness for Zach at some point during the trial. You know, I did have relevant information that they could have talked about to put the police investigation into question. And they didn't bother even talking to me about any statement that I could give, and that's unfortunate. But it's the reality that we have to live with now.
Winning, awesome. Hey, welcome.
What's up, Winning?
So Long Kong keeps going with the mailbox. That wasn't emphasized. We know Long Kong, but no, and that in fact, when I first interviewed you, Solomon, after this trial ended, I think it was like a week or so afterwards. One of my questions were, what? Were you not available? Why didn't you testify? There's a lot of stuff that I feel like you could have testified about, and you were never called as a witness.
Yep.
Next, we have Kim. Is it Kim Lavora? Talk to me about her. Who is this woman?
Kim Lavora. Oh, go ahead. You take this.
Well, she's basically a hookup that supposedly hasn't smashed yet. This is a woman that Rosalio had met on a Facebook dating app and had been texting apparently daily for a couple months. So really they had never met.
She was starting to get the ick from him. I think that she was friend zoning him because
probably she said that she was nervous and she didn't want to meet, and he kept wanting to meet and she didn't. So I think she's got children, and they had talked about how much they, how good of parents they were, I guess, or something. I don't know exactly. Their passion for their children was one of their talking points. So I think she's got a little better head on her shoulder than Rosalio. But that's just pure speculation on my part.
Yeah,
I think that there's some language that she used during her testimony that would be worth commenting on. She does get the time frame incorrect, and was Menards open as late as 8 p.m. or 9 p.m. on Sundays? It wasn't, or it normally isn't. So I don't know that would be accurate, or maybe Rosalio was lying to her. I
would assume Rosalio was just giving her a line.
But then
what do you think?
Also says when it happened. She uses. What do you think?
Yeah. I'm sorry. Yeah, I cut you off with the thing you wanted to say.
Yeah.
Way to go, jerk.
You did. But she used the phrase "when it happened," but when what happened? I mean, the state is asserting a narrative, but that doesn't mean that she knows what happened. She says when it happened, when what happened, and when did that happen? Because we don't have a concrete timeline on exactly when whatever it is happened. We have conflicting evidence.
It certainly should have been inquired further about.
And the defense never even bothered catching it and following up on it. Like, what do you mean when it happened? They never chased it. And maybe because they didn't want to give it attention, I don't know. But I can say that the verbiage is strange.
It is very strange. And this isn't the first time that we have some weird verbiage, or the only time, I should say, in today's testimony, especially with some of the things that Gravely says. But
Get wrecked, Gravely.
I don't understand. Gravely. Get wrecked, Gravely is our theme for today. He has a lot of issues. Now, I don't know what the purpose of this witness was, Kim. What was she trying to establish? I mean, I'm the defense counsel. I'm thinking, what information is this woman presenting other than?
I think what she was trying to do is explain that Sadie wasn't the only woman in Rosalio's life, but I don't think it came across that way with this witness. I think that she had to have again been more straight to the point. I think she left too many things kind of flailing.
I mean, that's the impression I remember getting when I was watching the trial. I went back through my notes, and it was like, I think I even put down there, like, the victim was a player. That's what I put down in my notes. So I get that, but to help advance the narrative, I don't know. Because there's the idea, like, well, maybe the whole meetup thing with the first Facebook girlfriend that testified, maybe something went off there. She was really cagey. The timeline didn't work. The messages didn't work. The fact that she went to the wrong place didn't work. Something was up there. She knows more than she's claiming. But now if you throw another woman in there, then the first one becomes just another woman in my mind. So that's what I'm thinking. Like, did this really advance anything? So then we get on to James Kendall, whatever. Kendall.
Yeah,
not even close, bro.
If it matters.
Colonel Sanders. Just call him Colonel Sanders for Christ's sake.
Colonel Sanders. What did Colonel Sanders have going on? Let's see here. What do my notes say?
I mean, I will say that the state did drop the ball, or not the state. The state really recovered and turned Kim Lavora into their witness. They really pushed the Dad of the Year narrative that they had been pushing with Rosario. And they were,
did backfire. That backfired with Kim. That's what was in my freaking notes.
And they were allowed to continue to push. There's an objection from the defense, and the prosecutor. Now, David, you know the rules of evidence and how it's supposed to be presented. But the argument that Jessica makes to the judge is that they need to establish that Rosario is dead. So they need to make this statement or follow this line of questioning with the defense's witness. And the judge then overrules the defense's objection. And that didn't seem proper to me. Why is the prosecutor arguing that they need to make their argument with the defense's case in chief? It didn't have anything to do with the direct examination.
Again, this is more of what I feel is a defense failure than a prosecutor taking advantage of some loophole or shenanigans, right? Because any witness that's called, you can use to help prove an element in your case. And that's true whether it's criminal, civil, whether you're the state, whether the witness is called as a defense witness or not. So you have an obligation. When she said we need to prove this, we have an obligation to prove this element. And why not bolster our already substantial testimony regarding Rosario no longer being alive than with a defense witness? It's the same thing as if you say the defense or say the state called this woman here, Juliana. Say the state called her, and the defense got her to say there was no indication of blood. Right? That's the defense's position. They're using a state witness to do it. It's the same both ways. So that's why they're allowed to. Now, could they have argued cumulative? You know, we've already heard like 5 witnesses testify about how much he loved his kids. Sure. But I think that would have made him just sound even more scared of this testimony.
I mean, should they have argued that it was all hearsay? I mean, she had no idea what Rosario was doing.
That would be a better argument, is hearsay. What did she argue? Not relevance, right?
I think it might have been relevance, actually.
But there's also an argument could have been outside the scope of direct.
They also didn't make that argument, and
they
that's
could have argued outside the scope of direct. They could have argued cumulative. They could have argued hearsay. Well, I don't even know what their objection was. But
it's absolutely hearsay. But then they would argue, that, or maybe it was hearsay, and then the judge overruled it.
No, it was absolutely hearsay. Because you can't get it as an effect on the listener, present sense impression. You're offering it for the prosecutor said in response to the objection. Clearly, they're offering it to prove the truth of the matter asserted, that being that Rosario is dead.
Right.
So it's obvious, it's hearsay. I don't know what their objection was. I forget.
But they're trying to argue that it was an exception because they needed to be able to fit this into the case, and that it was necessary to prove Rosalio's death. And then the judge was like, carry on.
You would think that the state would have had the death of Rosario proven before they rested their case.
No.
Yeah.
You would think.
No.
You would think.
But anyway.
Law Kong says he figured out why Kim wasn't a witness for the state, but he won't say. He's keeping it hidden. Okay, so going back to James. Did we have anything else with James?
I don't even really remember him that much, if I'm being completely honest with you.
What did James?
He was very quick. That's all I remember. I don't even have notes about him.
He was on and off the stand.
Wait, what did he testify about? God, I can't remember. See how good of hosts we are? We can't even remember what the freaking witness.
He was just that memorable. That was all. He's just an insignificant little man. That was all.
All right. So now, whoop, that's the wrong one.
Then we get
Now we come to the to the main star of
we
today.
actually, before we even get into the callback of Munch, we get into litigation, some really heavy litigation. They push for a few things. They talk about directed verdict. So they asked the judge to throw out all 4 counts.
Yeah, but they harped on the 2 stalking charges, and particularly count 2, which was the stalking against Rosalio. And I thought they were perfect arguments being made. And although I understand Schroeder's assessment at the end of the day, I believe he could have easily have kicked, especially count 2 with regard to Rosalio, and been absolutely fine with it, and probably would have made it could have made an impact on the outcome of the case. So essentially what you have to prove to be what they argued anyways, is that you have to prove 2 particular elements with regard to stalking, assuming everything else is undisputed, that Rosalio was afraid and that a reasonable person would have been afraid. And so they talked about so the state argued in rebuttal to the motion that Rosalio absolutely would have been afraid, and then went on to argue the reasonable person standard. Like a reasonable person in that circumstances would have been scared, frightened, or whatever, but then also him specifically. But he didn't argue it that way. And then the judge kind of walked him through. He's like, well, what you're arguing is the reasonable person standard, not the second element, which is Rosalio. And I have to agree with the defense that when you say, I'm not afraid, I'm coming for you, that could potentially mean that he's actually not afraid, right?
Well, he flat out says, right, I'm not worried. Those are the exact words that he sent via text. Alongside text saying that he wanted to beat him up and break his legs and all this other nonsense.
Could not be less distraught about the situation. I'm not worried.
Yeah, he did go on. Yes, Baldo Gagger 4000. It is the same Judge's Rittenhouse, because he actually goes on to mention the fact that the judge's family, and the prosecutors involved were apparently doxxed during that case. Their addresses were given out, and the judge was like, they got it wrong. So I wasn't scared, but I was annoyed, and annoyed is not an element. So you have to be more than annoyed. But he used his own personal example in this, which is very Judge Schroeder like. But yeah, so of course that was denied. All the motions for that were denied. And then there were additional arguments regarding gravely mouthing to Mr. Washington, die, 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 during Washington's testimony the prior week. So the defense had subpoenaed Court TV's records to get an unedited version of it, and then anticipated going into that with Mr. Washington when they called him back to the stand, which is going to happen in a minute, but wanted to address that with the court. And so Judge Schroeder actually grabbed a copy of the file from the defense that they had subpoenaed and received, and then watched it on the stand to determine whether or not Gravely was actually mouthing the words or essentially coaching the witness from the table. Gravely looks super concerned during all of this. He's like, Judge, you don't need to look at this. It's just smoke and mirrors, Judge. Smoke and mirrors. Just forget about it. Forget about it. He was super nervous during all of this. And you can even see it on his face, which is one of 3 of our The More You Know.
I saw the third one. So
die, motherfucker.
Maybe it doesn't show it 3 times.
No, it shows it twice. Yeah.
Yeah.
Yes, I did.
Okay. I'm gonna keep this.
I love that. I'm gonna keep this.
I'm gonna keep this. Not accepted as evidence. It's how he's clearly pissed about that. He's very angry about it. Now, there's
Gravely in the beginning of that, or are you trying to go back?
There was one thing that I wanted to mention about the directed verdict conversation before we jumped off of it, and that Gravely convinces the judge to ignore all of the directed verdicts using hearsay and persuasion and a circular argument to try and tip the judge off the edge. So the judge is working through the problem in his head and thinking out loud. So the judge is like doing this thing where he's talking about his personal view or what he's processing from each side of the argument. Gravely inserts himself into the judge's personal narrative and then uses hearsay, unproven, unpresented evidence, and calls the spot blood in the van, which is an opinion, and all this other stuff to try and convince the judge that that he should not throw out any of the charges.
Not only does Gravely call it blood, he identifies it as specifically Rosalio's blood was found.
Yeah.
He testified in that statement.
Oh, you know what? It's funny you brought
lied.
that up because at one point Gravely says, well, Rosalio is dead, and the judge is like, I can't make that determination. That's not for me to take notice of. That's for the jury to determine. And then
Gravely's done it the entire trial. He's done it repeatedly over and over and over again in this trial.
Yeah.
Anyway, so back to the mouthing incident. So we had quite a bit of discussion about that. Now they didn't play it for him initially. They talk about it and then they bring Munch out. They then wait until it's brought up in questioning because the judge decides to defer until the moment to decide on whether or not it's even going to come in, and then has to kick the jury out in order to address this issue, and then watches the video. So just so we're on the same page.
Right.
Well, in the video, take note as well. In the video, the defense, everybody's seen the video, right? We all saw it in real time. It's blatantly obvious that it was simultaneous, right? It was happening at the exact same time. And if you watch the video back today, you can tell when Gravely stops answering his question and starts mouthing. It's still in the clip, right? Gravely finishes his question and then mouths along with him. So it's very blatantly obvious that it was simultaneous. Get wrecked, Gravely. And on top of that, everybody in the courtroom identified it as such. Even Schrader eventually came around and was like, yeah, it's pretty obvious that this is simultaneous. Gravely maintained that he said it after the fact, and after Gravely said it, then Munch repeated that lie.
And
which is an interesting position to take.
And Gravely stuck to lying to the judge about how it was twice the entire time. Oh, I didn't say it a third time.
Oh, I said it twice.
But the judge says it appears that you're starting to say die the third time, and the court feed cuts. He calls him out on it. The judge calls him out on lying to him in the courtroom. Actually calls him out. The evidence is in front of the judge's eyes, and Gravely still lies to him. And this is one of those pieces of the ethics that we were talking about in episode 1. This bad man theory. He's lying intentionally. Why? Why is he defrauding the court?
Because he is scared of what this witness is going to testify to now that he's been recalled as a defense witness on direct. And he's so scared. You can see it in our next episode of The More You Know.
And I'll just summarize these, but you had said that he was sleepless and
Objection. This is all leading. So this is a recalled witness. I'm object leading.
Well, Judge, first of all, this is originally the state's witness, so I would ask for some leeway to treat him as a hostile witness. I think that's fair.
I'm going to overrule the objection. Go ahead.
Well, you were in on a federal case, right?
I'm federal MA, yes.
Right. And in KCDC, there's that's one of the facilities that the federal government uses to hold federal prisoners, right?
Objection leading. Hold on for just a minute. What the purpose of these facilities are is where it's a yes or no question. Leading.
What he knows, and again, this is.
I guess what I'm is there a dispute about a particular issue?
There isn't. I'm hoping we will get to something as opposed to.
Your objection is overruled.
Thank you.
Yeah, is there a dispute about the fact that this is also a federal facility? No. Okay, your objection's overruled. He's just He's so scared. This isn't the only time he objects constantly during this witness's direct examination.
For this one and the next one.
Well,
And
yeah,
they-
we're gonna get to the next one.
He tries so hard to try and get the video to be not shown in the courtroom.
Oh yeah.
To the point where he tries to twist what Munch says on the stand about not remembering, because the way they got it in was to refresh the memory. So they removed the jury from the courtroom because a refreshing memory or presenting evidence to refresh memory is not normally seen by the jury. So the jury is removed from the courtroom. They play the video to refresh the memory, and Gravely makes the argument that he said that he doesn't remember. He says he doesn't remember, which is different because Munch actually said, "I'm not sure."
Yeah.
Yeah.
Not I don't.
But here's
remember.
the other thing too, though, is that refreshing memory is used when the witness doesn't remember. So your argument that he said he doesn't remember isn't an excuse for not playing the video for him. That's exactly the point of playing the video for him. And I don't know if he's that dumb or playing that dumb. But it's just really bad, and it's really apparent all day today that Gravely is scared of these witnesses, particularly Mr. Washington and the next witness, which is Mateti. So he's deathly afraid, not deathly afraid, but he's very scared of what these witnesses are going to say.
Yeah.
Which just goes to show the level of confidence he has in this case, right? I mean, this is not a strong case to begin with.
Or at least in his system for this case.
Well, I guess. But yeah, so what else did Mr. Washington testify to other than no? Every time he was confronted with an accusation. No, I don't know Mr. Mateti. I never stayed with him. I didn't talk with him. We can't hear anybody in the cells. So essentially what the defense was arguing is that the next witness that's coming up and Mr. Washington had a conversation about, hey, if you want to get a deal on your federal case, just agree to testify about something random. You can make it up. Doesn't matter. If you agree to testify, you'll get a lighter sentence.
Jump on the case is what they refer to it as.
Yep.
Jump on the case. Yep. And he denied it. Nope. No idea what you're talking about. Never heard of such a thing. Oh my God. People do that.
Are you an informant? I wouldn't say, if that's the word you want to say. He was very shady and shifty the whole time.
I mean, he's clearly an intelligent person, right?
Very much so.
He's very much so. He's smart enough to keep up with the prosecutor as the prosecutor is feeding him information on how he's supposed to answer his questions. He picks up pretty quick on how to interact and what to respond, to the attorneys, and then to deny and play stupid with the defense. He did a good job of that. He's really good at that. And I mean, there's a reason why he's out now, because he knew to play the game. And so he did.
6 times convicted or charged. I don't remember. He knows the game. He knows the game, and he's playing dumb. And I can't imagine a single juror member thought this was credible. I can't. I can't. I'm gonna go with the DNA testimony convicted Zach, not this guy. It can't be. I have more faith in society than that, but I don't know.
I don't know.
He's a career criminal. He clearly knows the legal system. He knows the loopholes. He knows how to get away with what he can get away with.
Gee willikers, that seems wrong. I would never do such a thing. And then we get this guy, who, by the way,
before we have Mateti, we have a break in between, and during that break, what do we hear?
We hear Recovery Addict.
We hear our good friend Recovery Addict.
Now,
yes, we do.
Now, we don't have anyone's computers to see who was streaming the content in the courtroom. We actually don't know. It played over the microphone or over the sound system for the court. But Valhalla, you pointed out something that should narrow it down.
Well, there was one computer that had its volume turned up specifically to listen to the die video.
Yeah, hang on. Let me just replay a clip.
I say I saw the third one. So
Die, motherfucker.
maybe it doesn't show it 3 times.
No,
There you go. So you see the judge's computer was up.
The judge's personal computer, because he couldn't plug the jump drive into a state equipment, right? So he opened his personal computer, played that video, and then immediately following that, Recovery Addict's voice can be heard commenting on the case.
Fireworks in the courtroom.
Yes, Judge Schrader says something along the lines of, "Oh, we don't need to hear that commentary on this case." He doesn't say, "Whoever has a device turned on, please silence their device," because he knows exactly whose device it is, and he knows exactly what commentary is playing at that moment. It says like 3 words, and Schrader says, "Oh, the commentary on the court needs to, blah blah blah."
He said, and I quote, "Now we're getting commentary on the case," and then he goes like he laughs it off or whatever.
It's pretty obvious in my humble
the jury's
opinion.
coming in. I don't know if the jury heard that. I don't know where they were coming in, but they were coming in when that was going off. So I don't know if they were in the courtroom yet or making their way down the 21 steps that he has counted.
Because it was immediately when right after he phoned the jury to come back in. So he phones the jury to come back in, and then this plays over the court audio, and like everyone, Recovery Addict was stunned. Like if you actually watch the stream where he's like,
"Oh, that's me."
He's listening to my stream. Like he's like totally blown away.
Yes. So I forgot about that. Thank you for reminding me. But then we get to Mateti. Now, I will say, out of all the witnesses that testified, this guy is the most honest. Yeah. That's my gut instinct. Because eventually on cross, he's confronted with smuggling drugs into the jail. And he's like, "Yeah, I did it. I have a drug problem." He owned it. He took responsibility for it. And he is the most honest, I would say, out of all of the witnesses that testified. I really liked him a lot. But he's going to testify, or he did testify, that in fact he was offered a plea deal as well. He was offered a plea deal the same as Mr. Washington, but he decided to turn it down because, by the way, he was offered the plea deal because he was bunked with Zachariah for a few weeks or a month or whatever it was.
2 separate stints.
Two separate.
Yeah, 2 separate.
For a couple months at a time.
Yeah.
Yeah. And so, but he was offered a plea deal. Do you think Gravely wanted that plea deal in?
Not anymore.
Getting back to what we were talking about before in terms of there's no agreement right now, but at some point there was some sort of offer?
Objection. This is irrelevant, and there is absolutely no way that there's relevance in this situation, Judge. Calls for hearsay.
I don't agree with you. The objections are overruled.
Was there a point where your understanding, without saying who said what, but your understanding about whether or not there potentially would be a situation where you would testify for the prosecution?
Yes.
And what was your understanding?
My understanding was that.
Okay, sorry, sir, I apologize.
I'm sorry, but could he finish his answer? Wait.
He wants to make an objection, I assume.
Yeah. Objection. It sounds like it calls for what his attorney has informed him, since I'm not aware of any other basis, and that would be hearsay and would be an improper area.
Do you want his attorney to testify?
Well, I would suggest to the court that Mr. Mateti is not the person who should be able to report that, because it is hearsay and is not appropriate for him to talk about that.
Well, then Mr. Gravely is going to be a witness because.
Please.
Well, no, because.
Please. It's not hearsay because it's not being offered, I assume. Well.
This face he makes.
But I think it's an exception under the subsection 4 plan. So the question is really inquiring into whether he's been asked about whether there had been a deal discussed. And of course, he would gain awareness of that through his attorney, but it's not being offered to prove that there was a deal, but rather what his intent was. So the objection is overruled.
The whole purpose of this witness is to say he was made an offer to testify the same way, and he talked to Mr. Washington about it, and then he talked to the prosecutor and decided he could not do it. He could not get himself to just make up something like Mr. Washington did. And so to say like you can't get into that, it's impermissible hearsay, it's just nonsense. He's just scared of it.
He's
scared of
terrified.
that particular testimony.
Which brings in the discussion about State v. Tabor, and most of it is an ego stroke of Gravely for the judge, which
We
is
picked up on that.
It's also not relevant, and the judge actually agrees with the defense that it's not the same argument, but Gravely insists and keeps referencing State v. Tabor even after the judge says it's not the same. And
Well, but also every time that he mentions State v. Tabor, because this is a case that Schrader wrote the opinion on. He made the decision, the appellate court upheld it, and now it's a pride thing for Schrader, right? Every time Gravely mentioned it, he would be like, well, I agree with your legal analysis of the situation. Ha ha ha, all chummy about it. Like, yeah, it was a great case that I did. I know it was a great case. Every single time it was mentioned, he giggled like a little.
Let me give you guys some background, because we looked up this case. We looked up various versions of it, and essentially what it is a guy was charged and convicted of SA with a child, and the issue was whether or not they could use a prior conviction and the absence of an allegation from another child in the home, whether or not that was appropriate. To exclude the absence of the other child not being touched and the inclusion of a prior conviction. That's the only issue. It's not relevant at all. But Gravely mentions it over and over and over and over and over.
Like a half a dozen times at least.
It has no bearing on this. He tries to say that it's impermissible hearsay. It's not relevant. He tries to say it's not relevant. But that's not what the case is about. But he keeps using that case because it was a sustained case that went up to the Court of Appeals. And in fact, it came back down and went up in like 95. And then 2005, I think, was the most recent, or 2005 or 2007. Wasn't that long ago? It's fresh enough in the judge's mind that he knows, like, yeah, this is a case that got sustained.
So in that case, what is greater latitude to define? So essentially what they said is that when you're dealing with a crime that has a historically high recidivism rate, that you're given the court allows greater latitude to admit prior bad acts or other bad acts in conformity with this particular crime. So they use SA as an example, but there was a great dissent in a couple of cases that talked about, like, that doesn't make any sense. Oh, I should have pulled it up. I didn't. I tweeted it out. I can quote you. It says, and I quote from the Frederick dissent: "It is a device that permits judges to circumvent the law by making it highly probable that defendants will be found guilty, not on the basis of facts proved in the prosecution of the crime charged, but because they have allegedly been involved in SA in the past. The rule is unworthy of a jurisdiction which seeks to do justice. It should be repudiated in toto." This basically says that when you're using other acts to try and convince a jury when you don't have a proper prosecution, like in Zach's case, then a prosecution that does that to try and push a narrative that other bad acts are the reason why you should convict this person, not the actual fundamentals of this crime, that it is unworthy of a jurisdiction which seeks to do justice, and it should be repudiated in toto. That is an insanely powerful statement. And so
I just figured out what Gravely was trying to say here. What he's trying to say. So this witness, this current witness on the stand, is testifying that the other witness, Mr. Washington, is committing bad acts, and that any impeachment of that is irrelevant based off of the holding in that case. And that's what he's trying to argue.
That's the argument he's making?
Yeah, because at one point the defense brings up the fact, like, that case was about a victim alleging against a defendant, not a witness alleging against another witness.
Right.
So this case doesn't apply. That's exactly what he was arguing.
Yeah.
He was saying that it was improper for this witness to use the prior bad acts of this witness to impeach this witness.
Y'all, we've been trying to figure out why he
But
was
that-
citing
but
this
that's
law
not
It
what
just
all
popped
day.
into my head.
We've been
that's
trying
not
to
what
figure it out all day, y'all.
But that's not what he was doing either. It wasn't based on other
No.
bad acts. It was based
No.
on the relevant information that exchanged
And-
between them. He was a witness to it, and so he was expressing that to the court. And so it's still a mischaracterization of what that case law is. So
Well, that's what
either way,
Schrader
it's
ended
wrong.
up deciding in the end, right? He said it's not because of this law, but I'm pretty sure it's still somewhere in the law that this is the way to do it.
Yeah.
So,
So okay. So let me try to explain it. So
It makes sense now, at least.
Mr.
Finally.
Mateti is being called to impeach the credibility of Mr. Washington. All right. Mr. Washington said he was the confession witness, right? Zach confessed to this guy. And the argument from the defense is that this guy is basically just making it up in order to get a better deal. So, in addition to calling him to the stand to inquire about Gravely mouthing these words to him, they also call McAtee to the stand to say, yeah, I was made the same thing. I spoke with Mr. Washington about it. Mr. Washington said, oh, yeah, just make something up and you'll get a sweet deal. It doesn't have to actually be the truth. Mr. McAtee said, well, I'm not about to do that. And I'm going to turn this offer down because I have nothing to offer the state as far as testimony against Zach because Zach didn't say anything. And so what the state is trying to do is say that this witness is not allowed to testify regarding this guy lying, essentially. Hopefully that makes sense.
It finally does. We've been trying to figure it out all day, y'all.
But it still
And the
doesn't-
judge said, and the judge sustained it to some extent, but still allowed him to be questioned about whether or not they had discussions and what they talked about. So
right. Gravely tries to insert a case within a case by going deeper into lines of questioning with the witness to try and get some other sort of bad information on the record in front of the jury, even though it was totally improper. He's called out for it. He's denied the continued questioning to a certain extent, but he'd already rung the bell on a number of
Well, there was a part of that line of questioning at the end that really started to bug the snot out of me. And tell me if this is something that should have happened in a courtroom, because it didn't seem right to me as an idiot goat farmer, right? Schrader at one point, every single question is being objected to. And Schrader at one point, instead of making a ruling on each objection, says, I'm just going to give you 3 minutes total to ask whatever the hell you want, whether it's good, bad, or illegal. Basically.
yeah,
I added
that was
last part.
frustration. That was frustration with the counsels.
Yes.
That's what that was. That was extremely.
Ooh.
That was just frustration. Yep. I'm done with dealing with you. I am done suffering you. You got 3 minutes. Go. We're done. And that's exactly what that was. We had the same thing actually in the immigrant shooting thing, the border patrol in Arizona. The same thing. The state was limited to like 30 minutes to cross-examine this woman, and you're done. So with that though, we are done for today.
That's it. Yeah.
So we ran over. You're welcome, Jung. Tomorrow's a big day. Tomorrow we have day 14, 15, the verdict and sentencing. So it's a long stream, but we're here to talk about all of it. We're going to get through the rest of the case tomorrow. So don't miss out on that. It streams on my channel at 9 a.m. Eastern. It streams on Solomon's at 8 a.m. Central.
What is the name of your channels, gentlemen?
Solomon Says.
Solomon Says. Check it out. And then I am MLS God of Law.
There we go. I am
so
Valhalla Awaits.
Yes.
And then it's a pretty long stream. It's about 8.5 hours, something like that, for all of those days to be woven together. But it felt like the right way to do this. Tomorrow evening for the last episode in this series, then covering the trial, Jen actually joins us. So
yay, Jen!
My other half, the real expert on this case, gets to join us and talk about the last little bit of watching her future brother-in-law get railroaded.
Yep. So, all right. Take care, everybody.
Can I leave us on the one final word that it needs to be left on? Get wrecked gravely, y'all.